I'm fortunate to have three very well qualified and lively panelists, and I'm looking forward to our discussion. I'll just do some very brief introductions. Sabri Shawa is a partner in the Jensen, Shawa, Solomon, Duguid, and Hawks firm in Calgary. He's been practicing law since 1990, and in addition to his practice as a litigation counsel, he is arbitrator, mediator, and negotiator. He has a chemical engineering degree, as well as an LLB and an LLM in dispute resolution. His practice has encompassed a wide range of commercial claims and professional disputes. And he was appointed Queen's Counsel in 2012. He's a member of the Chartered Institute of Arbitrators and is listed in the 2013 and 2014 editions of Best Lawyers in Canada in the field of alternative dispute resolution. Stephen Antle, next to Sabri, is a dispute strategist. He is a senior partner in Borden, Ladner, Gervais, and a chartered arbitrator. Stephen is an expert in preventing and managing all kinds of commercial disputes and, if necessary, resolving them through negotiation, mediation, arbitration, administrative proceedings, or litigation. He has a broad range of experience emphasizing strategic corporate governance advice, domestic and international commercial arbitration, and he advises and represents a wide range of large corporations and individuals. To Stephen's right is Norm Emblem. Norm is a senior commercial litigation partner with Dentons Canada LLP. It's hard to keep track of all the firm names these days. Many of you will still remember it as Fraser Milner Casgrain. The focus of Norm's practice is acting for and advising accounting firms, and in particular the big four Canadian accounting firms, primarily in securities-related class actions, often with cross-Canada and cross-border implications, as well as regulatory proceedings involving the Ontario Securities Commission and other accounting professional bodies. He's acted for a number of major corporations, and he's had extensive experience in formatting ADR solutions and programs in conjunction with the kinds of proceedings that I've just listed. So, getting right into it, I thought a provocative way to start the first kind of orienting session of what's good and bad about arbitration, or when do you use arbitration and when do you use litigation, is to pose the question this way, and I'm going to pose it to Sabri. Most dispute resolution clauses are pre-dispute. Yeah, you enter into a contract, you've got an arbitration clause, or you don't have an arbitration clause. You've got a jurisdiction clause, or you don't have a jurisdiction clause. Then the dispute arises. And we know that in a certain number of cases, once the dispute arises, the parties don't quite like the choice they made with respect to how to resolve the dispute. They have an arbitration agreement, but they don't really want to arbitrate. And so they'll start court proceedings and try to defeat the arbitration clause. Or alternatively, they didn't have an arbitration clause. Now they're in litigation, but they think maybe arbitration would be a better way to go. And they approach the other side and say, we don't have an arbitration clause already, but would you like to arbitrate this particular dispute? What are the circumstances? And as counsel, and most of us in the room have been counsel if we're not still counsel, we're open to doing these things. Sometimes we're open to doing things that in the arbitration world may be viewed as somewhat dysfunctional, but when we've got a client who needs them done, we're inclined to do that. So, Sabri, turn it over to you. When, if ever, would you either try to litigate a case where there's an arbitration clause, or try to persuade the other side to agree to arbitration where there isn't an arbitration clause?
So I'm just going to make a few comments to sort of introduce the question, and then look forward to hearing from my friends on the panel and from all of you as well. It's not always clear whether arbitration or litigation is required in a particular circumstance. Sometimes, for instance, it's not clear whether the dispute falls within the scope of the arbitration clause or if, for instance, there are a multiplicity of parties or a multiplicity of issues, some of which are clearly caught by the clause, some of which are not. There's a question about whether you should properly be in arbitration or litigation. And even if it is clear which one you're supposed to be in, parties can agree to whatever they want. So there might be an opportunity to either move a dispute out of arbitration into litigation, or conversely to enter into a submission agreement, for instance, and move something that's in litigation onto an arbitration track, or even start or even stay litigation by court order, and move a dispute into arbitration. The Arbitration Acts invariably provide that litigation can be stayed in order to move in litigation can be stayed in order to move into arbitration. And I think it's fair to say that the inclination of the courts these days is to show a fair bit of deference in the face of an arbitration clause, and require parties to abide by their agreement to arbitrate if somebody is challenging the issue. I put together a chart that's in the materials that lists a number of issues or maybe attributes of both litigation and arbitration. Things like the cost and the pace and questions of confidentiality, all of the sort of characteristics that you might look at in respect of each of those processes. I don't propose to go through that with you. It's there in the materials if you want to have a look at it. I'm tempted to call it a list of pros and cons of litigation and pros and cons of arbitration, but really the point that I sought to make with that chart is that there are a number of characteristics that mark each of those processes. And from a strategic perspective, those aren't necessarily a pro or a con in any particular situation. You have to look at your particular circumstance, recognize that there is a difference between arbitration and litigation in each of these sort of ways, and then decide from a strategic perspective whether it makes sense for you to move or to push for one or the other. And I guess the point that I'm trying to make in all of that is that arbitration isn't just abbreviated litigation. It's a distinct process. It's unique from litigation. It has its own characteristics. I think one of its most marked characteristics is flexibility, and you can take advantage of that for whatever particular circumstances you might be in. So, by way of a very brief sort of example, let me tell you really quickly about a company that owns an industrial plant in Alberta. They recently undertook an expansion of the plant, and once it was finished, they realized that there were some serious deficiencies with the finished project. It became pretty clear that the fault resided either with the contractor or with the engineer, but it was, or at least not at this stage, is it clear which of those. So the contract between the owner and the contractor is a modified form of the CCDC contract, contains an arbitration clause. It's not entirely clear whether this particular dispute is caught by that, though. The contract between the engineer and the owner is a one-off agreement. It contains an arbitration clause, but it's poorly drafted, and I think the best view is probably that it makes arbitration optional, but it doesn't actually require arbitration. So the question for the owner in this case is whether they want to push the dispute into litigation or push the dispute into arbitration, and there's an argument for each of those. The determining issue in this particular case, I think, is this fact that you've got a multiplicity of parties. You've got two defendants, and you've got different considerations with respect to each of those. There's some complex technical issues, and they overlap a great deal. From the owner's perspective, whatever process is selected really has to involve both defendants. But you can see there's a problem in the arbitration clauses, and it may be that they're not able to bring both of those parties into one arbitration. So if they could bring them into one arbitration, that would be the preferable process, I think. The ability to take advantage of the efficiencies of arbitration is something that would be very important from the owner's perspective. The ability to select their decision maker, to pick someone who has some technical expertise because of the very technical nature of the dispute, argues in favor of arbitration. And there aren't any issues about things like interim measures that might push you towards litigation. So the problem, though, as you can see, is that it may not be possible for the owner to direct the dispute into arbitration. On the other hand, he might be able to. They have to make a strategic analysis and decide whether it's worth making the effort to push it into the arbitration process. Conversely, the defendants have to make the same analysis. They have to look at all those characteristics that are outlined in that chart that's in the materials and decide from their perspective, from a strategic perspective, are they better off trying to move the thing into arbitration or litigation? And they're going to be looking at the same features that the owner is looking at and making that decision, but looking at them from a different perspective. So let me just pick two of those sort of characteristics to sort of illustrate what I'm talking about. The first one that I was going to refer to is the question of the pace of the process. And I'm not talking specifically about the contract or just the construction dispute that I mentioned, just generally speaking. The pace of litigation, I think people would acknowledge, is often particularly slow, or can be particularly slow. Arbitration can be faster, although by no means is that universally the case. But I think from a strategic perspective, the opportunity to delay the process is greater in the litigation realm. And so if it suits a party to a dispute to delay the process, that might be a reason for them to want to move a dispute into litigation. So this is, the question of the pace of litigation, the pace of arbitration isn't necessarily a pro or a con. It depends on the particular circumstance that the party finds themselves in. The party might, maybe a defendant for instance, might find it beneficial to have a slow process and therefore want to be in the litigation realm. There may be good reasons for that beyond just wanting to delay and make things expensive and difficult for a plaintiff. The plaintiff might even want a slower process. It might be beneficial to a party to have a decision in a particular case deferred until after other events can take place, perhaps completely unrelated events. So the opportunity for delay that exists probably more in litigation than arbitration can actually be a positive feature depending on the strategic perspective. And so really quickly, just by way of another example, the question of precedent. I think it's fair to say that the courts are much better at following precedent than arbitrators, and there's a practical reason for that. Most arbitration decisions aren't available to be followed. So if, for instance, you're a party to a dispute where the case law favors your position, that might be a reason you would want to move a dispute into litigation rather than arbitration to take advantage of that. From another perspective, though, think about a party who has a number of disputes, and they may actually prefer not to set a precedent in a particular dispute because they may be facing a similar dispute down the road, and they don't want to be bound by the first decision. They may want to argue a contrary position in a subsequent dispute. And if they set a precedent in an earlier dispute, that may become difficult. So that might be a reason why a party would want to move a dispute into arbitration to try and avoid creating that precedent rather than being in the litigation realm. So I'm going to stop there and let the others on the panel make some comments about the question.
Okay, great. Stephen, did you want to?
Yeah, I think
Weigh in.
Sabri's chart, which you should look at in the material, it outlines what I would call the pros and cons of arbitration and litigation very well. I'm not going to say anything more about that. In my view, assuming the parties are in a situation where what they want is genuinely to resolve their dispute as efficiently as possible, it's a rare case where I would be trying to push them into litigation. I mean, there may be all kinds of other tactical agendas, and Sabri's alluded to some of them, that might dictate the choice of litigation in a particular case. But generally, I think the potential advantages of arbitration are just too good to pass up in most cases. One situation where I would be thinking about pushing a dispute into litigation is where my client required some remedy that an arbitrator could not grant for some reason. One general example of that might be an interim injunction. But even then, you could go to court, get the interim injunction, and then arbitrate the merits of the dispute. Something that comes up in my practice from time to time. I do a fair bit of shareholder work. The courts are given the statutory jurisdiction in this country to grant shareholder oppression remedies. And so often if you have a dispute that involves that, you need to litigate. Even there are workarounds, which I'd be happy to talk to people about later. There are ways of arbitrating oppression claims. Going the other way, where would you try and move something that was in litigation to arbitration? It's not hard to imagine a situation where arbitration starts to look better than litigation, but it's got to look better for both sides, because arbitration is consensual. You can't unilaterally move from litigation to arbitration. There's got to be an agreement somewhere. One situation arising out of the shareholder context where that has come up for me in the past is where I had a closely held company, 4 equal shareholders. One was going to leave, that was fine. One of the remaining 3 was going to buy him out, that was fine. But where they fell apart in their negotiations, of course, was over the price. So the leaving shareholder was looking at the only way he could get out was to bring an oppression claim, try and come up with some oppression angle, persuade the court to order the others to buy him out. Instead of going down that road, we custom designed an arbitration solely designed to tell us what was the fair market value of his shares on a particular date that we agreed on. We did that. That process took a month, that arbitration. We plugged that number into the share purchase agreement. He was gone. Now, contrast that with a shareholder oppression claim. So you can move back and forth. Those are some examples.
Okay. We had a case in our office about 5 years ago where once the parties, after 7 years of interlocutory warfare, learned the name of the presiding judge that was going to be sitting, immediately arrived at a consensual agreement that they were going to send the matter to arbitration. So that's not likely to occur too often because you don't know who your judge is going to be until maybe a couple of days. But it was clear to both sides, notwithstanding the posturing, that neither side wanted this case tried by this particular Ontario judge. So that's kind of a one-off. When you talk about the benefits of litigation and arbitration, it's easy if you're talking about a very clean arbitration where there's not going to be a dispute over what's caught within the arbitration clause, what rules apply to the arbitration, and you've got both sides that actually want to work together with an arbitrator that's going to keep the litigation attitude outside the arbitration. One of the themes that we keep hearing about, and Justice Binney referred to it this morning, that the short, sweet, no delay, informal, expeditious view of arbitration is honored more in the breach. Many arbitrators, and I've talked to Bill about this case, if you don't control the parties who come to perhaps an arbitration with a litigation attitude, you're going to end up with a process that might be 3 times as expensive as court because you're paying for counsel, you're paying for the arbitrators. And so what have you achieved? You've achieved nothing. So a lot of the benefits, perceived benefits, and it's amplified in Stephen's paper, which I commend to you, if you go in and both sides want to working reasonably, and they've got an arbitrator that's not going to let the matter get out of control, arbitration's great. If you have an arbitration clause, there's many examples of cases where it ends up in litigation because of the scope of the clause is fought. And it's partly humorous history in Seidel and Tellus, which Justice Binney decided 2 years ago at this conference. counsel on that party were on a panel, and I was on the panel. And the decision, if you remember, is one part of the case, a representative action, was permitted to go before the BC courts. The rest of the case had to be arbitrated. And what was interesting is about 10 months after that decision came out, those counsel were still fighting as to whether the court proceeding would go first or the arbitration matter would go first. So in a perfect world, there's many, many attributes to arbitration. In Ontario, for sure, the delay in the court system is become a bit of a joke. You wait for 10 months to get a motion date. You wait for years and years to get a trial. When you go to trial, that trial judge is under tremendous pressure to get the matter done in the 5 or 7 or 10 days that you have certified the case is going to try, because they have another one coming down the pipe. So for years you've told your client, look, we've got a great case, and you get in there and you don't have the ear of the court because they're overburdened.
Right. Yeah, I think it's a rare case myself where if it's unclear that you're entitled to be in arbitration, it's a rare case, and the other side doesn't want to go to arbitration. It's usually not worth the time and trouble to be fighting for 2 or 3 years about whether you're going to litigate or arbitrate if your purpose in favoring arbitration is cost and expedition. I guess there are exceptions to exceptions, but generally speaking, that's my view, is that the benefits of arbitration are there. They're definitely there, but they are maximized when you have parties that really want to access those benefits. And unfortunately, it's wishful thinking. If you've got one or more significant parties to the dispute that doesn't want to access those benefits and is going to cause problems, it may be wishful thinking to think you're going to achieve that paradigm of arbitration that everyone's talking about when they talk about why arbitration is better. Generally speaking, I have the same bias that Stephen does, in that all of the reasons for favoring litigation tend to be bad reasons. The only one that I can think of that is a good reason is when you do have the multiple party that's and it's not covered by the arbitration clause, and you really do need to have finality. And that was the example that Binny gave us in his keynote address this morning. All right, so the next topic that kind of flows from this is that it all has to do with the certainty of the arbitration agreement as to whether or not you're really going to be able to derive the benefits you hope to get from it. And I'm going to ask Stephen Antle to comment on that topic, and in particular, but not limited to, whether in drafting an arbitration agreement it's better to define the issues for arbitration narrowly or broadly, and if so, how to go about doing that.
So those of you who heard Ian Binney's keynote address and will have heard some of his comments about some of the uncertainties that can, you can't ignore that can come up in arbitration. Some more have been addressed already in this presentation. What that points to is, as Bill has said, arbitration, although it's the same kind of process as litigation in the sense that a neutral resolves questions of legal rights and obligations and imposes a resolution of the dispute on the parties. It's the same kind of process as litigation in that sense. But how you get from A to B can be, and in my view, generally should be, very, very different. And how you get there without tripping over some of the problems that Ian Binney talked about, that some of us have talked about, is by involving, from the beginning, from the drafting of the arbitration agreement and then all the way through the process, counsel who understand how arbitration works, that it's not litigation, that it can be different, and this is how you make it different. And you can avoid at least some of those problems by doing that. One of those places is drafting the arbitration agreement itself, and in particular the question of the arbitrator's jurisdiction. Arbitration 101, an arbitrator has no inherent jurisdiction. He can only do what the parties agree he can do, and that is agreed in the arbitration agreement. So, rather than copying and pasting something into your contract from the last contract you did, you got to give this some really careful attention. And the general choice is between a broad jurisdiction and a narrow jurisdiction. Or put another way, how broad a jurisdiction are you going to give your arbitrator? My view, unless there's good reason to carve something out, something that you want to send to court or to some other process, you should give the arbitrator as broad jurisdiction as you can. You should give them the jurisdiction to resolve everything that could conceivably come out of this contract or this relationship or this transaction, whatever it is you're dealing with. Again, unless there's good reason for an exception. Why? Well, again, we've heard about already this morning the benefits of arbitration. And I won't run through them, but if you're drafting an arbitration agreement, presumably you've looked at those benefits, you've talked about it with your client, and you've decided that at least some of those benefits are important enough that you're going to choose this process rather than going to litigation or something else. So you want to actually realize those benefits, right? They don't just fall into your lap because you put the word arbitration in your contract. There's more to it than that. And I'm talking in a commercial context here. So, business relationships are complex. A relationship is often governed by several agreements. There are often multiple parties, as has been discussed. You can imagine several different kinds of dispute coming out of a commercial relationship. There could be a breach of contract dispute. Maybe there's an arbitration agreement in that contract. There could be a negligence claim. There could be a misrepresentation claim. All of those could come out of any commercial context. If you've chosen arbitration, if you want to realize the potential benefits of arbitration, you want all of those disputes to be resolved by arbitration. And you have to give the arbitrator that broad jurisdiction. If you don't, then some part of your dispute is going to have to go to litigation by default because you haven't given the arbitrator the jurisdiction to resolve whatever it is. So then not only are you not going to realize the potential benefits of arbitration, but you're going to be in at least your client's worst nightmare. You're going to be arbitrating and litigating different aspects of the same business relationship probably at the same time with all the logistical problems that throws up. So in my view, unless you've got good reason to carve something out and send it to court for some specific reason, you should be giving your arbitrator as broad a jurisdiction as you can. ADRIC's standard language is pretty good in that respect, the sort of language that talks about all disputes arising out of this agreement or any legal relationship associated with it. That sort of language is what, in my view, you should generally be using. Now, my panelists will probably disagree with me.
I don't know that anyone wants to disagree with you on that. It's certainly I agree with it. I'll mention a wonderful case out of England that everybody should be aware of called the Premium NAFTA case. It's Lord Hoffman's decision. In fact, I thought about this last night. I thought I should have included it in the materials. If anyone wants a citation, I can send it to them. But it's a decision which dealt with all this jurisprudence that we see where the courts parse whether the agreement said, are we dealing with disputes that arise under this agreement, or are they only disputes that arise as a result of this agreement, or disputes with respect to this, and they were all interpreted as giving jurisdiction over different kinds of disputes, just those kinds of variations in wording. And Lord Hoffman says, this has not been Britain's finest hour in jurisprudentially, and we've got to draw a line under those cases and basically say that's nonsense. What we've got to focus on is the fact that parties wanted arbitration to be their dispute resolution mechanism in this business relationship, and if they've given us an indication of that, then we'll go with that unless there's something to the contrary. But unfortunately, you cannot rely on decisions to be made consistently by judges along that line. And so very comprehensive language really is needed.
I think, Bill, part of the problem is that the draftspersons of corporate agreements are, they live in a copy the precedent and stuff it into an agreement on the 11th hour world. So if everyone here that knew what deals were being cooked up at their client's office or upstairs on the corporate floor and went and said, look, if you're going to put in an arbitration clause into this document, it has to be meaningful. I think there's blind adherence to precedent, and then it gets into litigation, and you have the people that don't want to arbitrate say, well, it's not covered, and you have the people that do want to arbitrate trying to stuff into the arbitration clause things that were never even envisioned. So if you started from today and everything going forward had these ideal clauses, then there'd be less fighting. But the reality is the gators get these things, say, well, that's not covered, let's go to court. And you know, and then 4 years later, whatever the result is, you've blown your brains out in costs.
Yeah,
Right.
the narrow grant of jurisdiction really is a time bomb, as everybody's been sort of talking about. Compromises mediocrity, right? I mean, if the compromise is, well, some stuff will go to arbitration, but not everything, you're not going to get a satisfactory process. You're better off everything is in litigation or everything is in arbitration, because otherwise you have these competing processes and fights about which one you're in and those sorts of things.
This really points out something that again, as Norm suggested, I think is often not done in the copy-paste world of corporate law. But what you really need to do, and those of you who are arbitration counsel need to talk to the corporate people about, and the corporate people need to understand this and talk to the clients about, is when you're deciding, when you're at the front end entering into this contract, you need to sit down and take off the rose-colored glasses and say, how could this relationship go wrong? What sorts of problems are likely to come up? And how, bearing in mind things like Sabri's chart of pros and cons of different processes, how do we want to resolve those kinds of problems? And then what language do we need to put in our arbitration agreement to capture what we think is likely to happen? Instead of just using some language from some other document, you've really got to think about it. And it's an uphill battle for folks like us to talk to the other people involved in that process and get them to think about it. They all think, oh, no, it's never going to happen. But we make our living out of all the times it does happen.
Right. Oh, we've got some. David.
Taveter, Calgary. My observation on the last important discussion is that most arbitration clauses don't occur at the 11th hour negotiation. They occur at 11 hours and 59 minutes. And no time is spent, generally, in getting the information and the advice that's required. So to all of our corporate friends and our solicitor friends, get this way up on the agenda.
Sir?
Kent Witter from Kamloops. I'm an arbitrator. I'm also a lawyer, but I haven't practiced law for, other than being an arbitrator for 20-some years. What happens is, I hate when I get one of those agreements that says all disputes arising out of this contract. Because what about signing under protest, which I recently had, signing under duress, breach of a condition precedent. So those can arise, and you can refer them to the court when they're disputing the jurisdiction. But what happens when you're already appointed and you're there, and you're sitting back and this issue comes up? Do I really have jurisdiction? So I find that the best way around this is to say, okay, I'm appointed pursuant to your agreement, pursuant to the clause in your contract, but I also want you to sign a submission to arbitrate. And in that submission to arbitrate, I try to open up. And if they agree, they've agreed to the submission. So, but there is a jurisdictional problem, and I'm quite aware of the NAPFA case because that was argued in front of me.
Right. And I had one of these just a couple of weeks ago, exactly this, where the clause just said any dispute with respect to any term of this agreement, and the defense was that the agreement was void because of lack of independent legal advice and so on and so forth. And I did find that I had jurisdiction based on the fact that even the defense, as it was framed, did raise issues with respect to terms of the agreement, because there was a term of the agreement that said, for example, I've received independent legal advice. However, we do have to bear in mind we're preaching to the converted here. This is a congregation of the faithful that we're addressing here. We probably don't have many corporate lawyers in here, and we may not have a lot of lawyers in here who really do prefer litigation. And for example, in that particular matter, the argument was made to me, the reason why you should limit the clause to just matters that relate to a specific term of the agreement is because, now I'm going to paraphrase this, arbitration is kind of a rinky-dink way of resolving things, and it's okay for these small disputes, but this is fundamental, and for fundamental rights, you really need litigation. So you're dealing with attitudes out there about arbitration versus litigation, and unfortunately it's fueled by some decisions of the court that do draw lines where we can all debate whether they should be drawn there or not. For example, lines that exclude oppression remedies. There are cases on both sides of that, but certainly there are quite a number that do. And you wonder, well, is that really justifiable from an arbitration perspective? Yeah, please.
Yes, thank you for your remarks. My name is Dimitri Manianis. When speaking to about jurisdiction, certainly the arbitration clause is attention needs to be given to that. There's no doubt, but I'm observing that special attention needs to be given as well when speaking about jurisdiction to the definition of the dispute. Because as we know, the tribunal's jurisdiction is crystallized at the time of its appointment. And the rules tend to provide that the specific tribunal's jurisdiction is limited to the dispute that's submitted to it. And especially in complex relationships, commercial relationships, factual settings, what we have been observing is that by the manner in which the dispute is defined in either the notice of arbitration or whatnot, you can play with the jurisdiction of the arbitrator. And in fact, we have experienced cases where there's parallel arbitrations underway because the tribunal was originally constituted with a specific dispute in mind, defined by the claimant, and not properly, let's say, expanded by the defendant in the response. And so the tribunal's jurisdiction was improperly limited to a scope that was unfortunately narrow.
Right, that's a really interesting point. Subsequently arising disputes or whatever, then one party says maybe they're already reading the tea leaves on the panel that they've got. They got another dispute that arises, and they take the position, well, that's a different dispute. We want a new panel for that one. Yeah, that's really interesting. And I wonder. I don't know that I've ever seen any wording in an agreement that actually addresses that particular problem. And you hate to think that every problem that you can think of that might arise is going to have a wording solution, because then you get wordings that are just so unwieldy. Please.
Sometimes we've seen, instead of the clause requiring the tribunal to resolve the dispute, it's expanded to say that the tribunal shall resolve all matters related to, arising from, or in any way connected to the dispute, so that the tribunal's jurisdiction is not limited exclusively to the dispute as defined.
Okay, all right.
A fair point, but I can see if you end up with 400 words where 60 would have done, you're inviting somebody to say that that's ambiguous, and it's a recipe for litigating. We can all look at clauses and say, do you want us to attack this or defend it?
Yeah. But it raises a good point for counsel as well, that if you are on either side of a proposed arbitration, you've got to look at how the dispute is framed. I mean, I've got a case right now where I'm advising some people about a shareholders dispute, and the question is, we've got a beautiful arbitration provision in our shareholders agreement. The question is, how can we frame the problem we have to fit within that, to raise a legal issue that fits within the arbitrator's jurisdiction? Can we do that or not? A lot of hair is being pulled out over that question this week.
Kurt.
One possible way to solve that is to forget about saying relating to dispute and make it relating to the transaction. Yeah. All disputes relating to construction of the Transamerica Building. Yeah. Or all disputes relating to the Transamerica Building. Yeah. And if you're really gutsy, all disputes between the parties.
Yeah, absolutely. I think, or the relationship between the parties, which I think was some of the wording that Stephen suggested. I'm not sure, though, that addresses this issue, Kurt, which is each panel is established for a particular dispute, and then if a subsequent dispute arises, it may make total sense to have it determined by the same panel, but you don't have a mechanism for forcing that.
Why isn't an amendment of the pleadings the mechanism? In the U.S. practice, we pretty liberally allow people to amend as it goes along. Now, if you're 2 years into it and suddenly a new dispute arises, it may not make sense for the original
You're into a joinder of claims issue at that point as to whether it's a claim that's properly joined or not, as kind of the legal analysis on that. So let's expand the discussion now to another aspect of pre-dispute drafting. And I'm thinking maybe we'll have some disagreement on this subject. Let's see if it pans out that way. How far should you go in your pre-dispute arbitration clause in specifying the rules under which the arbitration is going to be conducted? Pleadings, discovery, so it's a suggestion about interim relief and that kind of thing. Or perhaps we can even extend it to the institution. Norm, were you going to help us out with this?
Yes, because you circulated some topics months ago when I pounced on this one from a real-life example in the mid-'90s where we had a client that was a party to an agreement with an arbitration clause. There were no rules that were incorporated by reference, and we literally fought for close to 3 years on what the applicable rules ought to be, including whether the arbitration was going to be heard in a live hearing or whether it was going to be done by written submissions. And ultimately, the arbitrator, David Ewell, retired partner from Ernst & Young, posed the question, well, what else are these hearing rooms for at the then extant International Arbitration Center in Vancouver Harbor? So it harkens to mind the Bonnie Raitt song, Let's Give Them Something to Talk About. Let's give them something to fight about. If you give the people the rules, then there's a little bit of certainty. Then you're arguing over, well, do we really need this rule that we bought into in the circumstances of the case? If you don't have any rules, then one side for sure is going to show up and basically say, well, these are the rules of civil procedure. This is what I've been used to for 25 years, and we need this. Why do you need that? Well, should we have a telephone discussion on why we need it? An in-person meeting, there's 4 parties, nobody's available for 6 weeks. You're going to fight over how to conduct the arbitration. So I think, on balance, I think there is benefit to having some rules incorporated by reference with the latitude, if you've got reasonable parties, to waive having to follow a rule if the result, is not going to be driven by, extensive affidavits of documents having to be exchanged. If parties agree, we bought into rules that allow for the exchange of expert reports and calling an expert if the other side intends to cross-examine, that type of thing makes sense. Everybody agrees to that. If you bought into oral examination for discovery akin to the rules of court, and your arbitrator says, well, why don't we just do will-say statements, then if you agree to that, great. I think if there are no rules whatsoever, it's a recipe for disaster, even though you might say, well, that provides all sorts of flexibility. Parties are reasonable. You can be flexible. One side wants to, fight for 3 years on what the applicable rules are going to be, then not having any rules is a problem.
I have comments on this, but I'll invite others.
Yeah, I agree 100% with Norm. I mean, I can flip the thing around. There are several good sets of flexible rules out there, all of which can be modified by agreement of the parties. Why in God's name wouldn't you pick one? Why? If you don't pick one, you get to exactly where Norm suggested. You end up writing the rules as you go, one interim application at a time. And every one of those, the parties are paying the arbitrators to invent the rules as they go. It's a huge delay and expense. Jim McCartney and I were on a panel earlier this year where the parties didn't agree on rules. We had this situation. There were a bunch of other preliminary issues in that case as well. But the upshot, in part, of the parties not agreeing on rules was that resolving the preliminary issues became so expensive that the parties could not continue to fund the arbitration to deal with the merits, and they were economically forced to settle before getting to a hearing on the merits, in part because they hadn't agreed on the rules. They also hadn't agreed on some other things like the seat of arbitration and whatnot, but it's just an example of how bad a knot you can get tied up in, and it's so simple. I mean, the ADRIC rules, the BCICAC rules, any of the international sets of rules, a lot of the international sets of rules can be used in a domestic arbitration. Why wouldn't you pick one? Just pick one.
Let me play devil's advocate, and I'm not sure I believe this, but
You're not supposed to say that.
well,
I'll play devil's advocate, and I do believe it.
we're all, that's right. We're all friends here, right? So one of the problems with litigation is that you've got from a rules perspective a one-size-fits-all proposition. You've got the rules of court, and every dispute has to get crammed into that construct and be dealt with according to those rules. Now there are lots of variations on rules for arbitration, specific to industries, specific to particular sorts of problems, and so on. So by selecting the right set of rules, you can tailor the rules that you're going to end up within your dispute a little bit. But you do also have the opportunity in arbitration to do something much more freeform. And so the example you gave a minute ago, where you have a tremendous cost associated with having your arbitrator making decisions on a free-form basis, making up the rules as you go, is a legitimate concern. On the other hand, it is an opportunity for you to tailor a process that is specifically suited to whatever that dispute is, instead of picking a set of rules that are designed to apply to whatever situation might arise. You tailor the rules to do exactly what you need to do in your specific circumstances. And there's some benefit to that. I think you could conceivably end up with a much more efficient process by doing that. There's a risk, and this is the risk here, but you might be giving up an opportunity to take advantage of the flexibility associated with arbitration.
Well, I'm going to be the devil's advocate, and I actually do believe in what I'm about to say, and I base it on my experience. I've had about 70 active arbitrations where I've been on the tribunal, either as chair or sole arbitrator. The vast majority of those arbitrations, the parties have not specified any rules. The vast majority have been ad hoc. The vast majority, and by vast majority I mean 80, 90%, no institution, no rules, and away we go. And this has not been a problem, except based on how the lawyers treat the absence of rules. Okay? Actually, it all depends on how the lawyers treat the presence or absence of rules. Because if you have a set of rules that existed before the dispute, you can be sure that you're going to have a dispute about whether those rules should apply to the dispute or how they should apply to the dispute. And somebody who's got a crazy idea about needing something that's completely unnecessary is going to try and justify it on the basis, but it's in the rules. So the opportunity to be flexible and actually have a process that's designed for the dispute only exists if you make the rules for the dispute afterward. When we talk make the rules, we're not sitting down and drafting a set of rules. And in fact, when I look at some of the suggestions that are out there as to how to streamline arbitration and so on, and I say, this is so unbelievably complicated. Why would anyone going through these tomes about how to, you can choose this if that, and this if that, and this if that, you'd say, well, geez, I'll just go with litigation. I know where I am, rather than having to sort this all out and fight this all out. But it's not that complicated. It is not that complicated. I've got an article in the material. It's just 800 words in the Lawyers Weekly, and it talks about why do you need pleadings. Every set of rules that's out there will have some form of pleadings. Most of these arbitrations can be conducted with just issues lists. And I'm talking about millions of dollars in dispute. What is it you need to resolve this dispute? You need to know what describe the dispute. You need to know what the claim for relief is, so you know what that is. Then you need to have the evidence from the parties that they're relying on, including their documents. You need to have a little bit of exchange of information, and to the extent it can be justified. And then you need a hearing with some examinations and submissions. It's not difficult. It's very easy. And the only time you get into trouble with it is when someone's trying to riff off some pre-existing set of rules. Now, one of the problems with not having rules, and I come back to Norm's example, and this, I have had this experience. No rules. So the lawyers decide that the first thing they've got to do is agree on rules. And they will sit there for a year, 2 years, 3 years, trying to design rules. Well, that's not taking advantage of the arbitration process. I say to the lawyers, agree if you like, and if you can agree on the rules, you go ahead and agree. I can't help you if you agree. I can only help you if you disagree. Okay? So you let me know as soon as you know that you disagree, and I will provide you with the procedures. And it's so easy. There was one arbitration. The parties decided that they were going to be under the rules of civil procedure or some such thing. 9 months, I didn't hear from them. What have you been arguing about for 9 months? We've been arguing about whether or not the plaintiff should be allowed to amend their pleading because it's a withdrawal of an admission. Why didn't you tell me 9 months ago that you have this dispute? I could have decided whether it should or should, And so the point being, post-dispute rules are better designed for the dispute than pre-dispute rules. You have the ability as lawyers, counsel, to agree once you know what the dispute is on what the procedure is, and if you agree, that's going to happen. You got total control. If you disagree, you go to the arbitrator as soon as possible, and you will have a process set for you, and it will work. In my arbitrations, I never tell anybody you can't have discovery, you can't have depositions. Kurt and I were on a tribunal where this very thing happened. Say, you can have all that has to happen. You got to come back and tell us why you want depositions. Okay, they go through the whole process that we laid out for them. They didn't need depositions when they got there, and that's not unusual. In my experience, once the parties go through the process that's laid out for them of exchanging the information they need, including what evidence the other side's going to put forward, they don't need any more discovery. So that's the art of arbitrating, I think, and we need more people who are attuned to that paradigm that as soon as there's a dispute, we sit down, we figure out what we need to do procedurally to resolve this dispute. We set a timetable. It's going to be a 2-month, 3-month, 6-month timetable. It's not going to be we're going to have multiple motions to decide, whether or not this rule or that rule should be accessible. Anyway, that's my view. It is, I think I would have to agree that it's a minority view out there, but I put it out for your consideration.
I'll weigh in on the side of the devils on the right and maybe make it a majority, at least on a number count in the event, because Stephen asked the question, why would you possibly not incorporate rules? I think one reason for that, and it troubles me, is the rules of some institutes that say that you cannot modify, because your proposition was based on the ability of parties to modify it. So what troubles me, and what might be the answer to your question, is those institutes that purport to say that parties incorporating through their contract certain rules can't actually modify certain things, like whether it'll be administered or not. And there may be very good reasons why you don't want an administered arbitration, and you want it ad hoc, and you'd like to use the rules of the administrative body without having them administer it, but some rules suggest that you can't do that, and there's some decisions that suggest that you can't actually do that. So that might be one answer that weighs in favor of the devils on the right.
I mean, I guess I would respond to that by saying that is a factor that should influence your choice of rules, but not whether to choose rules. I mean, and everybody knows there's the UNCITRAL rules that are, good for ad hoc arbitrations. So,
Mary, did you want to say something?
I did. Brian and I are often on the opposite side of things, and we so seldom agree that I had to stand up and say, I agree with you.
I have to document this.
Yeah, exactly. In my 40 years of practice, I actually have gone completely from the left. I used to do presentations on this and say, you have to put as much as you can and try and agree to it, to completely to the right. And I totally agree with Bill. I think it's up to the tribunal. I think if you don't, the last process you have, you leave the tribunal, the chair with the discretion if you can't get the tribunal together. And typically, the chair of the tribunal will say, we want a procedural agreement from you within 30 days, and if you have issues, come back and see us, and then tell us what your procedures can be. And if there's issues you can't agree on, we'll decide what they are. And just as Bill said, sometimes they'll say it's premature to decide this, that, or whatever issue, but if when you get there and you can't decide if there should be discovery, we'll decide that. And I have to say, in my experience, that has worked out more effectively than trying to build more and on the front end. And I always have to stand up and say, for goodness sake, don't ever adopt the rules of any court. Use your arbitration agreement. I mean, your comment, Bill, was interesting, because I've had arbitrations under agreement where the parties had adopted the rules of court, Alberta, Ontario. And the arbitrator's view is our hands are tied. You've adopted those rules to the extent the parties want to take advantage of those 300 rules for whatever procedure they'd like to partake in. We can't really say no. Those are the rules the parties have adopted, and it's painful.
These rules are going to provide, someone's going to come up with these rules, they're going to provide for pleadings. I don't think in many cases you need to have a 90-day pleading process. They'll provide for motions. In my arbitrations, we don't have motions, we have conversations about things. And, you have a stack of motion paper like that, and I say, no, we're going to have a conversation about this, and I don't need the stack of paper. We want to do things differently. People have to get this idea across that if it's an alternative, it has to be different. You got to change your paradigm. I want to move on because we are actually running out of time. I thought at one point that we were not going to have enough material, believe it or not. So actually, I'm going to forego my, because I've been talking too much, on 3 versus 1 person tribunals. And why don't we continue this discussion on pre-dispute issues with the tiered resolution approach, Stephen. I think that's kind of flows from some of what we're talking about.
Okay. Well, and in continuing to try and keep the discussion lively and provocative, the question here is a tiered dispute resolution process ever appropriate? And if so, how can a workable one be designed? And again, just to be sure we're all singing from the same page of the hymn book, the tiered process is one of these things that says if a dispute arises, first the operating people will negotiate. If they can't settle it, the CEOs will negotiate. If they can't settle it, we'll mediate. If we can't mediate it, then we'll arbitrate, say. Something like that. So is that sort of process ever appropriate? No, in my view. Almost never. You might be able to construct an example that would persuade me otherwise, but no. Why not? First of all, it's not necessary. People come to you and say, we need to have this because negotiation is good. Mediation is good. We need to be able to negotiate and mediate. But the parties can always negotiate and mediate. You don't have to agree to negotiate in order to be able to negotiate. And same with mediation. Those are consensual processes. The parties can agree to do them at any time after a dispute's arisen. And if they want to, if they both want to, they will. You don't have to have it in the contract that says you must mediate. If the parties genuinely want to have a go at mediation to resolve their dispute, they will agree to mediate. And flip side of that, if their contract says you must mediate and one of them doesn't want to mediate, it'll be a farce. You will have one of them in the mediation room going, no, no, no. And how much time and money will you waste before you get to a process that can actually solve the problem? So the tiered process is not necessary in my view, and putting it in there is counterproductive because, second part of the question, it's really hard to draft one of these well, to draft one of these so that it's clear and everybody understands and agrees on how it's going to work. In my experience, these kind of tiered processes are recipes for litigation. They're recipes for preliminary litigation about how the tiered arbitration, mediation, negotiation process should work. And because you have to litigate that, you give up most of the potential advantages of the tiered processes. You give up confidentiality. You give up efficiency because you're spending 18 months in court figuring out how your tiered process works. I mean, just one example. These clauses often include something like, the parties will negotiate in good faith. What the hell does that mean? What it means is that the party that wants to stall can easily take a position that says, you didn't negotiate in good faith, so you are not entitled to escalate this to arbitration. And you can spend 18 months in court sorting that out. It doesn't matter if you win or lose. You spend 18 months in court sorting it out in public. So don't do it. If you're going to try and do it, the key, and we don't really have time to deal with this here, but happy to chat later about it. The key, in my view, is to stay away from subjective terms like good faith, like best efforts, to use really short time frames so that this process moves, and to use language along the lines of, if the dispute has not been settled for any reason within 10 business days, then somebody can escalate. Keep it short and sweet and clear, and the process moves along, and eventually you get to arbitration, where an arbitrator can actually solve the problem if the parties haven't been able to do it. That's my thoughts.
One of the problems with these step processes is the limitation issue that can arise. If you have these preconditions to bringing your claim, you can find yourself outside a limitation before you get to the point where you can bring your claim. There's actually been some very large cases that have failed on that basis. So if there's a stepped process, you got to make sure you start the mediation portion of it in enough time to exhaust all those steps and still be in time to file your claim if it fails.
I think Stephen's point's good, and it's really comes home in his paper. I think it was very popular years ago to think about ways and means of allowing people to settle and spell them out before they were put to the expense of arbitrating. But as your point's well taken, you're free to talk at any time. You don't have to go jump into arbitration. The more you write down on a script in terms of the steps, the more there is to fight about. Now, if you had something like on a time delay, if the matter hasn't resolved by mediation without building in the subjective terms of good faith, acting reasonable within 25 days, and somebody unplugs their phones and is gone sitting on the back of an elephant in India, then so we want to arbitrate now. Well, you know what? This is a fundamental breach of this agreement. You're AWOL, and if there are unreasonable players involved, there's going to be fights all over the place. But
So-
I think the tiered approach is probably not the greatest.
We have to realize that everything we've said is pouring water on about probably 100 different ADRIC sessions that have been held on why these tiered resolution clauses are absolutely de rigueur. I will add to the pylon by saying that I have known these clauses to cause problems in my practice. I've never known them to work the way they were intended to work, but I do understand the theory of them. The theory of them is that a party that wants to start a negotiation or have a negotiation doesn't need to look weak in doing that. They can say it's in the clause. And so therefore, let's have the discussion. Now, I think it's a good theory. And so I'm not right there saying we shouldn't have these clauses. I'd like to be invited back to speak at some future ADRIC conference, unlike the rest of you. So let's stay on the good side of that. But on the other hand, to me, what's really important is ring fencing it. So whenever someone comes to me for that, I say something like, any failure to comply with the preliminary step or shall not affect the jurisdiction of the tribunal, the validity of its composition, or anything like that. But any complaint about noncompliance must be taken to the tribunal, and the tribunal can then decide what remedy, if any, to provide. So that gives the tribunal the option to say, okay, fine, you want your mediation, I'm going to stay the arbitration for a month, you go off and have your mediation. But it doesn't allow somebody to totally upset the apple cart based on saying you didn't negotiate in bad faith. So the ring fencing to me is the most important thing. So here are the topics we didn't cover and who was going to cover them. So if you're really curious, you can come and buttonhole one of us. I was going to talk about 3 versus 1 arbitrators. Norm was going to talk about document and information discovery and how that should be handled. And Sabri was going to talk about best practices for keeping hearings short and efficient while giving each party a full opportunity to present its case. I just want to say, on that last topic, Jerry Geekus just came into the room. I love to tell people the story about this hearing that I was fortunate enough to be on the tribunal. It was held in Madrid. Spanish arbitrator chaired. There were 9 fact witnesses. There were 4 expert witnesses. The materials were substantial. The amount in dispute was 10 to 20 million, depending on who you talked to about it. And the entire hearing took a day and a half. So, and all of those witnesses that I just mentioned were cross-examined. We started at 9, we went to 6, and it was easily the most efficient hearing I was ever at. I would never have believed it was possible. And in the end of the day, I would be hard-pressed to point to anything, any fact that bore on the issue that wasn't before us. There were no holes in the record where you sort of said, gee, I wish we'd spent more time on this or that. No doubt attributable to the skill of counsel, Jerry being on one side, and other counsel were involved as well. But in any event, it can be done. All of these things can be done, but we do have to recognize that if we're in the realm of alternate dispute resolution, we really have to think differently about what it is we're doing, starting from the ground up, and then do a kind of a functional analysis. So with that, I'm told we're out of time, and thank you all very much.